This has been an astounding day. And the amount of things that we have heard and we have learned have really been quite remarkable, so remarkable, in fact, that it seems like a few days ago when Clay Christensen was standing up and telling us about those 3 different kinds of innovation: empowering innovation, sustaining innovations, and efficiency innovations, and why it is that established players, oftentimes powerful established players, oftentimes find themselves making decisions that seem totally rational at the time, but end up opening up the space for the disruptors that end up eventually moving up the supply chain or the market chain and destroying them. And the question is, what's the relevance of that for the legal services market? We've heard a lot about what some of the constraints on innovation are, how much of those are regulatory, how much of those are cultural, how much of those are maybe a failure of imagination, of thinking big enough, of being confined within a scope of existing practices. How much of this is because we're not focusing either on the right questions or the right people who should be asking those questions. And then we've heard a lot from people who are trying to break free, who are trying to create innovations, who are trying to think differently. And we've had a number of terrific entrepreneurs who've shared with us what they're doing and the difficulties of what they're doing. And in our last panel of reporting on those disruptions, we heard an awful lot about what some of the questions perhaps that we're not asking ought to be. And the last panel really is designed to put those questions squarely on the table by asking people who are in the business, in a sense, of consuming innovation, and who are, in many ways, responsible for what the future is going to look like. We have 4 terrific panelists, although you only see 3 in front of you at the moment. You will, I promise you, see the 4th, who has been kind enough to beam in as well. And we're going to go in the following order. I'm going to start with Tom Sager, who's the Senior Vice President and legendary General Counsel of the DuPont Company. And I'll say in a minute about why I'm starting with Tom. We're then going to go to Paul Dacier, who's the Executive Vice President and General Counsel of EMC Corporation, making him both a purveyor of disruption in many markets as well as a consumer, as a lawyer. We're then going to go to Richard Suskind, who I think many of you know has written some of the most interesting and provocative things about the future of the legal profession. He has a home base in Oxford University, but he's everywhere, and he will appear up on our screen. He's actually listening to us now, sort of in an omnipotent way, which is, I think, only typical, fitting for Richard. And then last but certainly not least, and I would be the last person to say least, about my fearless leader, our leader here at Harvard Law School, Martha Minow, who is the dean. Oh, Richard just popped up. Oh, he popped away. Okay. I think he's looming over me saying, don't get it wrong, Wilkins. So that's the order in which we're going to go. Each of the speakers is going to have about 10 or 12 minutes, but we're going to do it in as interactive a style as possible. And I said I was going to lead in with a question for each of them about how they see disruption. So, Tom, I said I was going to start with you. And the reason I think most people in the room here know is that if you're talking about innovation in the market for legal services, DuPont has been really one of, if not the major company that's been pushing for innovation in the legal services market, particularly with respect to the relationship between companies and their outside law firms. I think what we now popularly call convergence, which is the idea of first, every great company had one law firm that did everything for them, and they were in the same building, and the senior partners model, son was married to the CEO's daughter, and they did everything from slip and falls to, the highest transactions. Then along came people who said, that's crazy, let's break up the monopoly, and then every company had 350 law firms, of which they constantly had to educate over and over again, and DuPont really was the beginnings of saying, no, we should have a different model, where law firms, we have a smaller number of firms, they work more collaboratively together, we network them, we work with them. That was a very important innovation, and I guess it probably started even as far back as the 90s, but certainly in the 2000s, and Tom, you've been very important in pushing that. And what I'd like to ask you is, looking from that perch of sort of having driven a change, which is now, I think, very standard practice, not just here in the United States, but I study lawyers around the world, and I think that model of convergence is coming around the world. What do you see now? And what are you looking for now in innovation from whatever source you are looking for it? What are you seeing and what are you looking for?
Thank you, David, and thank you for inviting me to participate this afternoon. I'd like to take you on our journey, which has literally been 20 years to present, and give you a sense as to why we started this process and why we are where we are today. But I did want to give you a little bit of background on DuPont. We're 212 years old, founded in 1802 on the banks of the Brandywine River. The first lawyer to represent DuPont was Alexander Hamilton. And he represented DuPont from 1802 to 1804, and of course you know his fate. He died in a duel with Aaron Burr, but there was a silver lining. They were both using DuPont gunpowder. And the reason the DuPont family elected to choose Alexander Hamilton, because he spoke the language, which was French. So fast forward to 1992, and the legal department in DuPont found themselves under siege. We were confronting that mass tort era, and we had thousands of cases and using hundreds of law firms, and we realized we needed to redefine our relationship with these firms so that it would be more than a matter of simply asking for rate reductions, which would not be sustainable, but we really wanted to redefine how we would work with them. The landscape then, I think for some of you in this room, is all too familiar. The system was very complex, and the CEO had a difficulty understanding it. The dispute resolution process was far too long. The risks were very uncertain and not very well managed. The transaction costs were high. There was no discipline and approach. We were highly reactive, not only in terms of the firms we selected, but how we went about defending our cases. Tremendous amount of inefficiency and resource intensive, and basically little identification with the client's needs. So we went about this process, and it took what we considered to be a significant transformation of how we were going to engage our firms. And I think David's already alluded to the convergence process, which took us 3.5 years by design, because we wanted to distinguish it from the typical RFP process. And we had to convince the firms that we were serious about this, and we really wanted to engage them in a way that they would not necessarily focus upon the next case, but the longer-term aspects to our relationship. And the best way I could explain it to them at the time, and many of them took heed and some of them did not, but we want to be have a mutual commitment to each other's financial success in the truest sense of the word. So through that convergence process, we went from 350 to about 34 firms and 150 ancillary suppliers to 4. And we created a vision, and we tried to define it in terms of strategic partnering, the longer-term view, alternative fee arrangements, how we could create certainty in billing, drive efficiency, and handsomely reward them for their activities if they did well. Embrace technology to drive collaboration, which will be a constant theme you'll hear from me throughout, and the importance of collaboration among our law firms and our in-house counsel. And of course, we were very much about advancing women and minorities in the profession as far back as 1992. So that vision carried us only so far, and we decided we had to give them a playbook, which is in the 5th edition. I'll leave this one with you, David, but basically it's how we took a very integrated discipline approach to litigation and other project work to bring more standardization and discipline in getting to closure with whatever the matter might be. So there were 5 elements to our model, strategic partnering being one, early case assessment, which you all are probably familiar with, strategic budgeting, alternative fees, and the use of technology. So the overarching theme here was proactivity, efficiency, and closure. We're hiring you to address problems, not to handle them. And along the way, in engaging these firms, we found we had to address any number of paradigms. David alluded to the first being the law firm selection. The criteria we used for selecting these firms was not your typical criteria, and it's framed in the book and otherwise, but basically we tried to emphasize the mutual commitment to each other's financial success, leverage our strengths, promote the relationship, share risk, reward, and otherwise engage actively with the client, not through necessarily the lawyer from within, but direct interaction with the client, the real client, the business client. Many firms took this concept and embraced it wholeheartedly. Others struggled with it, but that was the first pass in terms of how we went about selecting our firms. And the paradigm, of course, then was there was one gray-haired person like myself that was in charge of the relationship. We wanted to institutionalize the relationship and understand every professional that was going to serve DuPont in that capacity, because there more than one touch, certainly, with any number of firms. We also went about advancing temporary staffing, which at the time there was a mindset that temporary lawyers equal inferior quality. So we went after that with a vengeance, and we found quite the contrary. We unbundled our legal services. Of course, we used ECA to be very proactive in how we assess a matter and then devise a strategy for its resolution, figure out how best to staff it by way of resourcing with multiple law firms if need be, and temporary staffing agencies, and of course, figure out a way whether or not the matter would lend itself to alternative fee arrangements. So all of this is to say there are any number of paradigms we had to address: the importance of metrics, paralegal utilization, offshore document management, and most recently recoveries, which has been a real find for us. 10 years later, DuPont's in its third transformation. This would be 1999. We're shifting from a chemical company to a biotech company, and we found we were very well positioned to accelerate that transformation because what we had in place then was a dedicated network of law firms and suppliers who have reached the point whereby they were going to put aside their competitive interest and do what's in the best interest of DuPont, even if it's not always in their financial interest. And that's what we tried to lead by with the firm. And most of them adhered to that very model and were rewarded handsomely for doing so. So now we're dealing with the dynamic of globalization, in which speed and agility is critically important. It's an 80-20 world for us. We're not looking for precision. Of course, as we go beyond the United States, cross-border collaboration is a major, major theme of ours, and leveraging knowledge along the way. And so we're constantly promoting the theme of collaborative intelligence. Innate intelligence is certainly very important, but the lawyers we're looking for today are those that understand the importance of collaborative intelligence and drawing from various different perspectives and views, developing more than one option, and then lighting on one that they think is in the best interest of the client, or perhaps providing the client multiple options. So then we're into 2009. Of course, we had Lehman weekend, and the new reality set in. And of course, because these relationships had been time-tested over almost 18 years, we were able to weather that recession, hunker down into basically a survival mode, and those firms responded in kind. And they did amazing things to ensure DuPont's continued viability, while at the same time we were very mindful of the commitments they were making and the sacrifices they're making, because we explained to them there'll be a new day. And there certainly has been. And I think the firms that hung with us and evidenced that loyalty and commitment are now being handsomely rewarded. So what we're looking for our lawyers: collaborative intelligence and those that can anticipate the curve. And what I mean by that, look far enough out to spot those critical issues and those potential derailers for their clients. And in so doing, they'll help us advance DuPont's interest in parts of the world where we have very little presence. We're wholly dependent upon third parties, in many cases law firms. So we have to develop that candor and rapport as we have with our U.S. primary law firms and those in Europe and Canada and Mexico. So I probably have gone on a little bit too long, but It's a changing world. Globalization is a real driver. Collaboration is a much-needed theme, one that will only enable us to bring competitive advantage to DuPont in the years ahead.
Thank you, Tom. Thank you. And we'll come back, and we hope to have time for questions, so be thinking about them as we go along. But I'd like to go now to Paul Dacier. And Paul, I said you wore 2 hats, but you really wear 3, because you're not just leading general counsel in a company that is itself a disruptor in many ways, but you're also the president of the Boston Bar Association. And that gives you responsibility to think about our legal system and the legal profession as a whole, particularly here in the Boston area. And so, again, the same question: what are you looking for as you think about innovation and disruption and what you'd like to see happen?
All right. Well, thank you very much, and it's an honor to be with you all today. And this is a great topic for all of us to weigh. EMC was founded in 1978 above the Newton Lower Falls restaurant here in suburban Boston.
Really?
And Dick Egan was a manufacturer's rep selling office furniture. He then started to sell high-tech equipment, including memory boards. And then he and Roger Marino, the E and the M in EMC, and 2 other individuals decided to go into high-tech manufacturing of intelligent disk storage. The 2 C's in EMC decided to back out, which turned out to be a multi-billion-dollar mistake. When I joined the company in 1990, we were $160 million in revenue, and our market cap was about the same. We had a little bit of cash and no debt. I was the only lawyer at the time. Dick Egan told me he did the legal work. We then promptly got sued by a few of the world's largest high-tech companies at the time. They were out to destroy us because we were changing the world starting in late 1990 and into 1991 with how companies viewed information. We made information strategic, such that today, as you've seen the evolving technologies in cloud, big data, and trust, EMC is the leading entity in the world in this regard. And today, we're $23 billion in revenue with 60,000 employees, and our market capitalization is $55 billion. When we first got sued by one of the world's largest high-tech companies back in 1991, and I retained a great law firm, I got the bill for $32,108, and I thought, how am I going to pay this? But I quickly realized that EMC was a scrappy company then, we're a scrappy company today. We had to survive, and legal had to be strategic. Legal had to move faster than the business. We had to be the very best. And so today, I have 118 lawyers around the world, and we are the very best at what we do. Back then, when we filed our 10K 24 years ago today, we were proud to say we had 1 patent. Today, we have 4,000 patents and 4,000 applications pending, and we're noted by the patent board that's reported in the Wall Street Journal as having one of the top 10. We are ranked in the top 10 as being one of the great innovators here in the United States. With our law firms, because back then when we had a number of problems, it was just me, and then I hired a few other lawyers to work for me. But with our law firms, I kept the number very small. They had to know our business, they had to know what we wanted, they had to know that we moved quickly. Trade secret protection is the lifeblood of our company. When we had people stealing our trade secrets, we had 0 tolerance then, as we do today, which means we would sue that day. If we were doing an acquisition, we would do the letter of intent that day. We would send out the acquisition agreement the minute the letter of intent was signed. We'd have diligence done before anybody else. I can't tell you the number of acquisitions we've done over the years. And in particular, by the way, we've done 45 in the past 3 years. But over the past 24 years, I can't tell you the number of deals we've done, small, medium, and multi-billion, where we have beaten the competition because we've done it faster, which means overnight, on Thanksgiving, on Christmas, on Easter, or any other holiday where everybody else is having dinner and we're in doing the deal. All our lawyers worldwide know this, and we know that it's very competitive out there today. I will tell you that pricing for lawyers is getting rather astronomical. And I have said to some law firms that have done business with us for all these years, when you're billing me or wanting to bill me at $1,500 an hour, you're making it easy for me to look at somebody else. I understand the revenue pressures the law firms are under. I understand the argument that there could be too many lawyers out there, which I'll address in a minute. I understand that everybody wants to make $1 million a year or more, but reality has to set in. And I understand that the law firms have to change. And we do embrace technology. In my own department, we use big data. We use big data to analyze our patent portfolio, for example. And I can tell you not only the length of our patents and patent applications and compare them to what we've done in the past, but I can tell you instantly what other companies are citing my patents as prior art for their patents. And I can tell management instantly whether or not I have the hottest patent on the planet. And one of the analyses that my lawyers gave me today showed that. I also use it because I need it to run my department. My budget, as I said, is around $80 million, and I do look at this very seriously. I look at the amount of percentage that is to our overall revenues, and I compare that to what other departments in the company are doing, but also what my competition is doing. I have to be lean and efficient because that money, I'm an expense. Now, it is true, and many of the lawsuits that have been brought against me where I have sued back, I have turned into a profit center, which can be dangerous. And on some of my cases, I brought in some of the largest settlements in litigation history. But I take seriously that that comes and goes, and I have to affect how the company operates, because that money could be used for innovation. Speaking about innovation, look at the challenges that are being faced today in the industry with non-practicing entities in the patent world. In 2011, the reported number all in, the cost to the industry for litigation and settlements was $29 billion. The overall cost, management distraction and the like, and lost innovation was $80 billion. That money should be going to develop products, technology, and changing people's lives. So that's a major problem, and that's, I think, also an area that we as lawyers could work to be more innovative versus going into a business rather than a profession. Now, wearing my hat as president of the Boston Bar Association, I will tell you that I do see the world differently about the challenges in the legal profession. There is an overwhelming amount of legal work out there. It depends on what people want to do. Everybody is shooting for the stars, while the stars are shrinking. However, look at the number of self-represented litigants in the probate and family court here in the Commonwealth of Massachusetts. The self-represented litigant, the pro se litigant, that's more than 80% of those that appear before the court. Those people need help. If a lawyer today wanted to hang out a shingle and be a general practitioner and had the right price points, which I will leave up to people to define, there is an overwhelming amount of legal work, and the lawyers will have a very good living. It also is affecting how justice is rendered. And I believe, and we believe at the BBA, in the fair and efficient administration of justice. The courts today, in state courts, never mind the federal courts, are grossly underfunded. In the Commonwealth of Massachusetts, the number is way down from a funding point of view. For the trial court itself, 6 years ago, it was $600 million, went south to $517 million. They have crawled back today to $615 million. But that does not take into account the increased caseload and complexity. They've lost over 1,000 employees that have not been and will not be replaced. The courts need to keep up, and there are technologies out there today that could help them do so. They still have stacks of paper. We went into court recently on a request for a preliminary injunction on a breach of covenant not to compete, and I was horrified at the stacks of paper around the bench. I was even more horrified when there was not a court stenographer and it was all being tape recorded. And I said to my lawyers, write it all down. That's our record if we lose. If we can transcribe that overnight. I can't imagine how we're going to transcribe a tape recorder. The courts are struggling in this regard, but they should embrace the third platform and technology. The third platform is the mobile, the handheld. This would allow the courts to do things more efficiently, have more efficient access to records, allow us as lawyers to do so. This is the challenge that is being faced by the courts, subject to funding. But I do think that for everyone out there, you have to realize that there is more to law firm representation to corporations and wealthy individuals. There's a whole populace that needs help, and it's for us to figure out how to give it to them in a fair, efficient, and cost-effective way. Thank you.
Thank you, Paul. So, Richard, are you there? Well, 1 second. Is he going to pop up like the Wizard of Oz?
Enter the number followed by the pound key.
That's some low-tech technology for Richard. Well, Richard, did we lose him?
Enter the number followed by the pound key.
We had him. We should have kept him when we had him. I tell you what, why don't, rather than listening to
Connecting you to your destination.
Why don't you guys get, you're going to get him? There he is. Richard, your smiling face is even larger and more handsome than I recall. Richard, can you hear me?
I can indeed.
Wonderful. Richard and I are old and dear friends. Richard, nobody has thought more about these issues for a longer time in our business than you have. While you weren't able to be here with us, we had Mike Royden, who is in charge of the Watson Project. And he said, we're entering a third generation of computing that is just beginning to take off, that will allow us not just to have kind of static storage of data, essentially X's, I don't even know how to do, ones and zeros, right? And, you know, essentially spreadsheet storage, but intelligent thinking. And he went on to say that already this is having a very transformative effect in the world of medicine. And then he said, medicine and law have many things in common. And the question, I guess, my friend, is, having been watching innovation and having predicted many things correctly, like lawyers would use email all the time when they first told you, no, they would never do that, it would be a violation of client confidentiality, true story. What do you see on the horizon, particularly around the use of technology? And I guess just as importantly, what don't you see happening that you think ought to be happening?
Okay, thank you very much, David. It's a great pleasure to be with you. I have to forewarn, as you will have seen, that there is a minor technical problem, so I may disappear for 10 or 15 seconds. It might happen once or twice during my presentation. I won't dwell on video conferencing technology quite yet. What I thought to do, however, is just say a little bit by way of background to what I believe are the major drivers of change within the legal profession, and one, of course, is technology itself. Then focus in, having really highlighted some of the exciting things that are going on in technology, what I see to be the disruptive technologies, and say also a little about how this maps onto the 3 stages of the profession that I think we're encountering. And finally, I want to challenge to some extent, although I use the term myself, the term disruption. So the 3 drivers of change are what I call the more for less challenge, other people call it 2, liberalization and technology. Just a little bit about the first 2, and then I'll focus on technology as you've asked me to. But I think it is important to see the context of all of this. The more for less challenge, very simply put by clients who say they're under pressure to reduce their internal headcount, they're under pressure to spend less on external law firms, and yet they have more legal and compliance work to do than ever before. This, I believe, we can capture and encapsulate as the more for less challenge, and it will underpin, it will define, in my view, the next decade of legal service. There are only actually 2 strategies with which we can cope with this challenge. The first I call the efficiency strategy, which is largely how we can take the cost out of the routine, the repetitive, the administrative, the largely process-based work that's at the bottom of the metaphorical pyramid that so many people talk of in law firms. And the other strategy is the collaboration strategy, more radical, but we're seeing it happening with a number of general counsel around the world, where GCs come together and share the costs of legal services. So rather than duplicating effort by putting out similar work to many law firms, they establish or are planning to establish shared services centers to cope with the the work that they have in common is non-competitive. So that's the more for less challenge. The second issue, and I thought I should touch on it because it was touched on, I know, a number of times during the day, is liberalisation, our Legal Services Act, which Chris Kenny will have talked about, which it's very early days. Bill Gates said of technology that... We're back.
We're back.
Yes. Bill Gates says of technology that less happens in 2 years than you think and more happens in 10 years. And I think it's very much the same in change within the law. And so it's early days yet for our liberalisation, but the influx of capital, the influx of new energy, enthusiasm, new ideas, new applications of technology, it's really pretty remarkable over in England and Wales what's happened since the Legal Services Act has come into play. The future has arrived, it's just not evenly distributed yet, is what William Gibson, the science fiction writer, says, and it's true in law. But I know that the ABA Commission, 2020 Commission, rejected the idea of ABSs and liberalisation. I think that's a poor decision, both on moral and business grounds. I believe that as lawyers, we should thrive and survive because we add value, we bring benefits in virtue of our skills and expertise that no one else can. We don't survive and thrive by pulling up the drawbridge or essentially regulating other people out the arena. So I'm very much in favour of the entrepreneurial spirit, the new ideas, the new players, the new money that liberalisation brings. And the early signs are, I think, that this will contribute to greater rather than less access to justice. But let's talk about technology, because that's the focal point, I think, of my few minutes with you. You're right, David, and I always say it. In 1996, in my book, The Future of Law, I predicted that lawyers and clients would communicate largely by email, and the Law Society in England and Wales said I shouldn't be allowed to speak in public, which may well be true. They said I didn't understand confidentiality and security, and that I was bringing the profession into disrepute. What they failed to recognise, and we all know of course, is not a law of the land, but Moore's Law, that simple metric that we can summarize by saying every 18 months or 2 years, approximately, processing power doubles, which gives rise to this exponential increase in the power of technology. And many of you have heard me and others say before, if you follow the curve, and material scientists and computer scientists say we can do this, by 2050, the average desktop machine will have more processing power than all of humanity put together. And as I often also say, you can call me radical, but if you can see the day that the average desktop computer has more processing power than all of humanity put together, then it might be time for lawyers to rethink the way we, for example, draft documents. It seems to me unimaginable that the internet and technology is transforming all corners of the economy and society, and yet somehow it doesn't apply to law. You may think I'm exaggerating. Google's chairman Schmidt said every 2 days now we create as much information as we did from the dawn of civilization up until 2003 rather. We can hold all the world's recorded music in a little handheld device now. There are 5 billion mobile phone subscriptions. More people in our world have mobile phones than toothbrushes. The truth is there's no finishing line in information technology. If we'd convened 4 years ago, hardly any of us would have heard of Twitter. There's now 500 million users. Still, however, when I speak to major law firms and I ask perhaps a partnership of 500 how many people use Twitter, you'll get 4 or 5 reluctant hands going up. And I always joke, are they waiting for it to take off? It seems to me with 500 million users, it already has gained some traction. Just remarkable, however, and you ask for disappointments and gaps, I think, in our progress. One is what I call irrational rejectionism, which I define as the dogmatic dismissal of a technology with which the critic has no direct experience. It amazes me how many lawyers reject technologies without ever having sat in front of them. And it's one of our biggest obstacles to the introduction of sensible labour-saving devices. There's a huge point coming through, and it can be expressed through a number of enabling technologies, but I put it this way. Systems are simply getting smarter. In the 1980s, I did my doctorate in artificial intelligence and law in Oxford. And I shared a room, funnily enough, with a surgeon. He was working in medical diagnostics, I was working in legal diagnostics. And the IBM chap's absolutely right. The similarities are considerable. But what we're moving into now is a second generation of intelligence, where computer systems are no longer...
Always comes at a strategic moment. There you
yes,
are.
It adds a certain tension to the event, certainly at this end. Will I ever see you again is my feeling as I disappear. The second generation, I believe, of intelligent systems are coming through. And the characteristic, actually, that they share is that they behave intelligently, but are no longer, as we thought in the 1980s, modeled in human brains. Whether it be big data, intelligent search, AI in the Watson lines, machine learning, All of this is underpinned by, frankly, the brute force of computing, and we are enabling technologies that behave in apparently intelligent ways but really don't perform like human beings at all. And the big point here is that these systems are just getting smarter and smarter. There's a huge debate just now about the extent to which white-collar workers will have anything to do in decades to come. And I think it's a legitimate debate, because if you think of the growth in processing power and the advances in technology generally, it seems to me that many of the applications that will fall into this category of disruptive. In my work, I've identified 13 disruptive legal technologies. Each on its own will cause a ripple. Together, in combination, it seems to me they'll change the entire landscape. It leads me to say, in fact, that we'll see more change over the next 2 decades in the legal services market than we've seen in the last 2 centuries. So I'll run through what they are just very quickly to give you a flavor, and then a little comment on a couple of them. Automated document assembly, relentless connectivity, what I call the electronic legal marketplace, e-learning, online legal guidance, legal open sourcing, closed client communities, workflow and project management, embedded legal knowledge, online dispute resolution, intelligent legal search, big data, AI-based problem solving. These are the 13 I identified in my book, Tomorrow's Lawyers, last year. In my book, The End of Lawyers, I had a similar list, only there was 10. They grow by the year. Automated document assembly is disruptive because you're now able, in a matter of minutes, to generate documents that used to take days to handcraft. And it's disruptive because if you charge by the hour, this reduction in time does not make business sense for the provider. Online dispute resolution is perhaps more profound than any other. This is the idea of e-mediation or e-negotiation. The underpinning question is court a service or a place? Do we really need physically to congregate together to resolve our differences? Well, certainly people who have disputes in eBay, and I think there are about 60 million literally a year, don't seem to think so. We will see emerging, I believe, over the next decade, in the first instance, low-value disputes. We'll see them resolved electronically, quickly, cheaply, in a non-confrontational way, taking lots of work that's clogging up many of our courts, and also offering access to justice to people who otherwise wouldn't have access. That technology can't come quick enough, in my view. Intelligent legal search and predictive coding, it's pretty well established now that in terms of precision and recall, intelligent systems can outperform junior lawyers and paralegals when doing a first-level document review. And AI-based problem solving. If you look at what's happened through Watson, if you understand and appreciate the progress that's been made in medical diagnostics, we're not many years away, at least from having the technology, in principle, to allow us to sit down with a computer, an average citizen with a problem, to chat through the difficulty in natural language and for some kind of recommendation to emerge. These are highly disruptive technologies because they threaten the traditional one-to-one consultative hourly billing way of working that's dominated legal practice for so very long. So this leads me to say that actually what we're seeing is the legal world evolving through 3 stages. And the first stage is the stage I call of denial. And it really arose around 2007, 2008 with the economic crisis, when most lawyers, both in-house and in law firms, really were waiting for the economy to return so we could go back to the old way of working. So general counsel put work out to tender again. Law firms fired some people and proposed some alternative fee arrangements. But with all the will in the world, those of us who've studied EFA...
Back for the big finish.
Yeah, I think we can get to the end here without further disruption, if I can use that term. We know of alternative fee arrangements that actually they deliver about a 10 to 12% reduction in spend, and many of the GCs I'm speaking to are talking about a 30 to 50% reduction over the next 3 to 5 years. So denial, I think, that we really need to change. It's not really about pricing differently, it's about working differently, which takes us to stage 2, which is the stage what I call of resourcing. I've identified 14 or 16, depending on how one calculates it, different ways of sourcing legal services, the routine and repetitive work of undertaking that work differently. There's a message here, it's not just for law firms who need to rethink the bottom of their triangle, but also very large legal departments who have, just as law firms do, junior lawyers in expensive cities and expensive buildings, undertaking work that actually could be done by other providers and in the long term by technology. Because that is the third stage, and it's the third stage I call it disruption. Because so much of what we do, it seems to me, in what is the most information and document intensive industry in the world, can and will be in one way or another systematized, whether it be automatic document assembly or online dispute resolution or intelligence search or online price comparison systems and auction systems. We are in for a rocky ride in the legal profession over the next decade or so. And this is why people call it disruption. But to some extent, I want to challenge that term, as I've mentioned earlier, because disruption has, I think, rather negative overtones. And I asked the question, disruptive for whom? I think it's certainly disruptive for the supply side. A lot of the writings on disruptive technologies look at the law firm business model or the law firm delivery model and say that some innovations are fundamentally challenging for these. But from the point of view of the consumer, from the point of view of the client, many of these disruptions actually bring very good news indeed. They perhaps mean radical reductions in the amount of labor involved. They mean far speedier work. They perhaps mean less confrontational work. So the language of disruption, I think, applies to the supply side, but not necessarily to the buy side. I prefer really to look at the changes that are happening as constituting what I call incremental transformation. I don't think we'll change overnight. I don't think there'll be a tipping point, but I do think we'll look back, say 10 years from now and say, wow, we really have moved on a lot. The technologies that are second nature to all of us in our daily lives have now been brought to bear in law. They've disrupted the standard and traditional suppliers, but they've brought huge benefits. I hope access to justice for the many consumers and citizens who can't afford legal services, and also great benefits for general counsel who increasingly say they can't afford the legal risk management and other services that they too require. So disruption, yes, for law firms. I think perhaps salvation for others. We can expect over the next decade, at the hand of technology, incremental transformation. Thank you.
Thank you. Thank you. Oh, he's not going away. Actually, can we keep him? You can go away, but he'll come back for questions and answers.
Thank you.
Martha, so incremental, what did he call it? Innovation, change. In the next 10 years, things are going to be radically different. Your job is to prepare the people who are going to be radically different, or to prepare them to live in a radically different world. You have spent your legal career being both disruptive and innovative in all the best senses of those words. But you've never, I think, faced a challenge quite like the one you face now as the dean of certainly one of the most important law schools in the world and a leader in the field of legal education, and also in your capacity as a member of the board of the Legal Services Corporation, which is responsible for thinking about access issues in a creative way. So, Madam Dean, what are you looking for in this brave new world, and how are we going to prepare our students for it?
I want to be Wayne Gretzky. I want to be where the puck is going to be, not where it is now. And that's why I'm so grateful to David for his leadership manifested wonderfully by this terrific and disruptive conference and the entire program on the legal profession, and indeed all of you for participating. Because when I was asked 2 hours ago by my reviewing committee, what are we doing on these big issues facing the profession? I said, glad you asked that, because today we have this conference. No, what I want to say is that I do think that there are even some bigger questions that I just want to put forward on, for everyone to consider. I think that there are some paradoxical statements that people are making about this current moment, and it would be helpful to put the two pieces of the paradox together. So on the one hand, we absolutely see and will be wanting to push for more efficiency and the commodification of certain kinds of services. On the other hand, the demand for judgment, tailor-made, bespoke services has never been higher. How do you put those two together? Secondly, on the one hand, the rule of law and having a reliable set of institutions that are predictable is indispensable for effective operations of business and human relationships. And my own work in post-conflict societies has taught me that actually the first thing you need after a civil war is to rebuild the court system, or build one if they've never had one. On the other hand, if there isn't cultural sensitivity and respect for the traditions inside of a particular society, you will not have a meaningful and reliable justice system. Picking up a blueprint of what rule of law looks like in one place and putting it somewhere else without responding to the cultural specificity is a failure. So that's the second paradox. And the third one is, and I think people have alluded to this all day, we have too many lawyers, we don't have enough lawyers. Paul put it very, very well. We do have too many people who want to do the old-fashioned big firm practice. We don't have enough lawyers who are there actually meeting the needs, not just of poor people, but of middle-class people, all kinds of people, and small organizations. Small startup companies can't afford legal services. So these are the paradoxes that frame my remarks. What I would like to see, first of all, is more system design and design thinking. I think one of the challenges that we have because of the history of legal training is we tend to be case by case by case rather than thinking about systems. Here's where data can be helpful, but it's not just data. And by systems thinking, I think in part about Ken Feinberg, who teaches here periodically. How do you design a dispute resolution system after the BP disaster? It may not be that we just go through the Federal Rules of Civil Procedure. That is not a blueprint for solving a problem, by the way, I say as a civil procedure teacher. But how do you design a sensible system? Tom was talking about this before. And you know, if you have the resources, you try to design it ahead of time. If you can't design it ahead of time, you design it afterwards. How do we think sensibly about the right way to design systems, not just for post hoc dispute resolution, but also systems for doing deals, systems for incorporating the unintended consequence analysis while you're doing the deal, so that that's part of real-time thinking. And I do think about systems design in criminal justice as well. So, you know, we talk about the right to a jury, we talk about right to counsel. 98% of the cases are, of course, pled out. We need to talk about the actual system that we have. And are we spending any of the resources in a way that makes any sense whatsoever? From my work on pro bono task force for the Legal Services Corporation, I have to say I was spectacularly impressed by the pro bono work of some tech firms that have helped some legal services organizations create an online platform that allows for integration with firms to actually get a 2-hour chunked out piece of a case, and here's what you can do, and then you can put it on the platform and it will go to a next lawyer who can handle it. This is within reach. Systems design is what's necessary. Related to that is, I guess what I'd like to see is much more integration of assessment with service delivery. How do we look retrospectively about how things worked? Did they work? Not just how many cases were settled, and not just what was the amount of the purchase price, but, you know, 2 years later, what do we find out? 5 years later, what do we find out? And here I think we can learn from what some other professions and other fields are doing. I think that integrating assessment and service delivery is also something that we need to help lawyers do. How do you become able to have a dashboard for yourself about how well you're doing on various dimensions? And that includes on the dimension of building relationships and building relationships of trust. Because if you don't have them, then you actually can't provide the kind of judgment and trusted service that's needed. I actually, in addition to the jobs that David described, I'm actually running 27 legal clinics. So I'm in the business of legal services delivery. And I can tell you one of the things that I see a need for is much better privacy and security. We have major problems just keeping client records secure, dealing with Gmail and information that is spread that way and then it's not secure. these are issues that I'm dealing with right now. It may sound very mundane, but I would like to collaborate with others as you try to deal with what are the sensible ways to handle these issues. When my IT people, who I see almost every day, say to me, well, what do you mean exactly by security? There really is no pure security. Well, thanks very much. I need another answer here. I understand that I'm not going to devote my entire budget to security. But yeah, we're hacked. Everybody's hacked. What are we doing about it? And what is going to be our best practice about it? One of the biggest disruptions that's going on right now, besides to law, is to education. So K through 12 education is radically being remade in many parts of the world, certainly in Los Angeles, which now gives an iPad to every student. And then the teachers can watch how much time a student spends on any given lesson and relate that to how they're performing on the quizzes. Those students 5 years from now will be in my classroom, and I have to figure out how are we teaching them. I don't believe, personally, that you can videotape lectures and that people will learn anything what they learn right now in the way that we currently teach law schools. In law school, and I think interaction is absolutely central. But here are two examples of innovations that we're undertaking that I'd like to see more of. One is we're disrupting the casebook market. You know what a casebook costs these days? Anybody guess? $200, $200, okay? A book. So students are buying 10 of those a year. So that's expensive. And I say this as an editor of casebooks, which are paying for my daughter to go to college. But I will say that there's something very perverse about this, since most of them has as the core of their material publicly available judicial opinions. And so we've created here, through our innovative Berkman Center and library, an online platform that allows an individual, say me, to edit cases, put them up there. You can click a button, see the unedited version, and I, as a professor, can link it to my own comments, to invite other people to comment. We can use a Wikipedia-type process to have crowdsourcing. I can link it to videos, interview the lawyer behind the case, and David can use the same materials, edit them, make it a playlist, and modify it. And I think we may blow up the publishing industry as a result, but they're dying anyway, so that's okay. Don't quote me on that. And again, I'm on both sides of this because there go my royalty checks. But I seriously, I think that's an example of the kind of disruption that is already happening and that I bet on more than the idea that we're going to videotape classes and that's going to substitute for the case analysis that has made lawyers analytically sharp. But educational disruption is necessary, will happen, but I think we should be careful and not blow up what does work. The last thing that I want to say is that there's been a radical dropping off of the numbers of people applying to law schools in the last 5 years, since the financial disaster. It's down by about a half. And that, I think, is an overreaction to the changes that we're talking about. But I think that actually all of we grown-ups contribute to it, because we say the sky is falling, the field is a disaster. Guess what? Young people are saying, okay, then I'm not going to law school, and I'm not going to be a lawyer. I think that we're making a mistake here. There may have never been such an exciting time to be a lawyer. If you actually think about the opportunities for innovation, the opportunities for service, the opportunities for justice, the opportunities for rule of law and figuring out what that means in different circumstances, and the opportunities actually to take the parts of the job that had become quite drudgery and make them efficient and make them smart. That, I think, makes it an opportunity that any smart person, any young person ought to be excited about. But I really challenge everybody in this room to stop saying the sky is falling and tell young people this is a great time to go to law school.
Well, it's a great time for some of you to approach the microphone. Richard, if we could get him back up on screen and hopefully keep him up on screen. And while you do, this is really, I hope, the beginning of a conversation. And I guess I'd like to begin to have that conversation now about what is it we ought to be doing that we're not doing. Or what is it that we are doing that we shouldn't be doing in all of the various domains that have been put on the table? So I could keep talking, but I'm going to, this is not a shy crowd. So please, and the dean has agreed to stay with us till 6 o'clock, even though her visiting committee is
5:50.
5:50. See, she's already negotiating. So please.
All right, so earlier there was a comment about 500 people that could write a brief to the Supreme Court, but only 5 within a mile radius that could do project management. And now you mentioned the overpriced textbooks. We've talked about disruption in other ways. What about in legal education? Do you see any ways to drastically change and improve the quality of our legal education so it's more practical?
Yeah, well, I do think that that is a process of change that's been underway for the last 30 years. So when I talk to alums who graduated here 25, 30 years ago, they don't recognize what we currently do. And I would identify that to include simulation, major part of education right now. Clinical education, all of our students engage in clinical, practical education. So I think that the problem with it is it's much more expensive than the old way of teaching. The real challenge is, can we sustain the trajectory of the changes that have been underway, which are much more hands-on, much more feedback, much more apprentice-like. It's fairly expensive. So what I would hope is that we could take down the walls between the legal academy and practice, and have many more fluid relationships, so that right now our problem-solving class, every student takes a problem-solving class. David is a brilliant teacher of it. We should be able to connect by Skype or otherwise, practicing lawyers to give feedback to the students after they've watched, the students are doing a simulation. That's what I see going to the future. It's not cheaper. It's not less labor intensive, but it could be richer and better.
So
Great conference.
Dean, I
Please, go ahead,
assume
Tom.
the president, as you know, came out pretty forcefully with respect to the length of the 3-year.
A throwaway
Yes,
line at a press conference, but yes.
Our graduate.
Yes, my student.
And where do you come out on that?
I think that there's nothing magic about law school being 2 years, and there's nothing magic about being post-BA or a BA. What's fascinating is to see, in fact, the bigger picture, not just how long it should be. When should it be? It's fascinating to watch, the people in Korea and people in Japan go to a system like ours that requires a BA first, and others go the other direction. I think that nobody has figured this out quite. I personally think that we will see, and rightly so, a period of experimentation. We will see some 2-year law schools. There already are some, but there won't be more until the ABA changes its rules, because you can only have 2 years if you give up your summers, and I think that's a big mistake. I think that one of the things that we should really look for is something more like what's happened in the medical profession, which is the development of allied medical professionals, many, many different kinds of professionals. And everyone doesn't have to have the same exact training. That's what I hope we'll see. And I think that the unauthorized practice of law rules will have to change for us to have some more experimentation.
All right. So please.
A great conference, thank you. And I agree with Dean Minow's comments. He's back. Do you want me to keep going?
Yeah, no, keep going.
Okay,
Yeah.
I agree with Dean Minow's comments that it's a fascinating time to be in the legal industry, and maybe a great time to come out of a good law school. But I run a business at Huron Legal. I have 1,500 lawyers doing document review for me. I'm not sure they'd agree. We try to provide them with a great culture and atmosphere, but career track, honestly, it's quite hard. So I'm curious, encouraging people to go to law school versus the 1,500 who work for me and have a tough time.
Well, it's not a full answer, but that's what I meant about allied legal professionals. I think that there are different kinds of roles for people, and it's not clear that everyone needs the exact same training. I also think that jobs that involve some kind of rotation through different kinds of work is a way to make it continually interesting. I further want to add, and this is where I really want to emphasize, building assessment and systems design into the delivery of services. So just take a very simple example. You have a complaint line. You see that the complaints are going up. You respond to those complaints, but you also build in a system that will change what the rules were that have led. That's what we're missing here. What we don't have is the law reform piece that's connected to the service delivery. We don't have the, let's stand back and look at the system. If you had that, the people who are working for you would feel like they're part of a larger project. And, you know, an hour a week, they're actually, think about Google. Google is the, what is it, the 60-80 rule? They do 80%, they have to do what the company says. 20%, they do their own projects. I like the way that you can actually say to people, you can do 20% on something that's a big long-term project, but 80% is your day-to-day delivery. I think there's many ways to make it more interesting.
Yeah, I just have to very briefly respond. I mean, people do feel like they're part of a project. And I think we and our competitors, too, go through a lot of length to do that. But driving efficiency in a systematic way requires somebody to, go through 100 documents an hour, document a minute. It's hard to make that fun and fascinating. And it's a challenge. I mean, it's hard to have it both ways for us as an industry, I think.
I'm sure you're right. I'm sure you're right. And here's where people who know more than I do about what artificial intelligence can do to highlight what requires the human eye and what doesn't. There may be a very different dynamic 10 years from now, 5 years from now.
So, Paul, did you want to address that? And then, Richard, if you're back on, we can let you speak. Yeah.
Right. Just, again, lawyers are focused in on certain parts of the profession, but there's many more. There's more to the practice of law than litigation. Anybody can file a lawsuit. There are lots of litigators out there. There's only a few trial lawyers. Read the commentary from some of the federal judges in Boston, the vanishing jury trial. Most cases get settled. We don't settle, by the way, but most cases get settled. So, sure, talking to somebody about document review and doing certain things in a rapid fashion, that's going to be hard from a career path point of view. But look, people need wills. People get divorced. People have commercial disputes. People buy and sell properties. There's zoning issues, municipal law, tax issues. Go down the whole list. There are many aspects of the profession that are being overlooked. And I can't stress it enough. Today, the advantage is greater than ever. With technology, lawyers can have a robust practice with a minimum capital outlay and have a very good living and be very honorable in the communities.
Richard, are you back?
I am back. Well, you can answer me. Is my voice clearer?
Yes. Now it's
Excellent.
just the brogue.
I'll say something slightly different so I don't repeat what was mumbled earlier. I think the question I've been asking law schools around the world is what are we training young lawyers to become? I think it follows from a lot that's been said, certainly the sessions I've heard of today, that there is a whole bundle of new law jobs emerging. I, for example, point to the legal risk manager, the legal project manager, the legal knowledge engineer, the legal process analyst. The details of the job descriptions are unimportant, but I do think there are exciting new job opportunities out there. What I regret in most law schools, and I'm not referring to Harvard here, but in most law schools in the United Kingdom, for example, we are churning out 20th century lawyers. What we teach and how we teach really has not changed since I was at law school in the 70s and 80s. I've spoken at 10 law schools in 2013 in the United States, and I suspect the ones that invite me tend to be more enlightened. And my general feeling is that the US legal fraternity, the academic legal fraternity, is more alive to the change. And that might be because of your problems of the number of people who are now applying. But I do think that it's not simply about how we teach and the better use of e-learning and so forth, for which obviously there's huge scope. I think we need to take a step back and ask fundamentally what jobs lawyers are likely to be doing in 10 years' time.
Please, next question.
So at the initial point I wanted to make, but then something else came up, was just around the casebook point, and it's appalling, maybe, absurd, I can pick your A word, that we're still using case law as a means to teach, lawyers in 2014, unless we're sort of doing Future Law Clerks of America, which is a very, no one uses that to actually practice. And sort of tying that tangentially to the earlier point, on the liberalization idea, we've gotten to the point, I think, in terms of how we are monopolistically protecting the profession, that we're damaging the profession. Lawyers shouldn't be doing document review. There's a lot of work out there that the bars have sort of mandated lawyers do that is increasingly inappropriate for lawyers to do, and it's damaging, really, the profession. And that's why people don't want to go to law school anymore.
Anybody?
Well, I'll just say, case law, I think, cannot be the center of a legal education, but it's not going to be irrelevant. And there is something that we have learned, one way or another, that is developed by drilling people in what ifs with a fact situation. And the recent research about how the human brain works confirms that the human brain works by hanging details on a story. The story is what we remember. And so we may innovate new kinds of teaching materials, but there's something that explains why this one has endured for so long. We can talk about this later.
Yeah.
I absolutely agree with you, by the way. That's why we've gone from 5 paralegals to 70 and gone from 175 lawyers to 121 in Wilmington, Delaware, for that very reason. Lawyers should not be doing a lot of the things they're doing now. And, of course, we've got the unauthorized practice of law challenge. But I think you're spot on.
Marty?
Thanks. One of the most innovative things I heard today was just a sentence that Richard mentioned about the collaboration strategy in response to the more is less challenge. And I would love to hear more about the notion of some kind of utility model between companies trying to share legal services. That's for you, Richard.
Richard?
Thank you. Interestingly, I often use this as an example of why liberalization's important. I first raised this issue in 2008, where I suggested that many of the large international banks should perhaps overcome their massive expense on compliance. Many of them spend several $100 million a year on compliance. They could overcome some of this difficulty by coming together and setting up a shared services center. And the question was, well, who would actually set it up? And I often say to law firms, the major law firms around the world, who say they don't need further capital, that none of them could actually afford to invest in such a shared services center. So that's usually the reason why I talk about the collaboration strategy, because it's an illustration of the kind of new business that could be set up by UK law firms, but not by US law firms. That's one of the reasons I say you'll be at a competitive disadvantage. But there's a number of initiatives around the world just now, some in the public sector, local authorities in England and Wales, public bodies who've teamed together. Actually, one has recently become an alternative business structure under our liberalized regime. And they have looked basically at the huge overlap, the huge duplication of effort across these public bodies and said, we really don't need all to be paying law firms to do broadly the same work. So they've set up a shared services facility. There's also, in the United States, there's 40 general counsel. 40 general counsel have set up a similar venture to collaborate. And interestingly, they're from different industries and different sectors, as I understand it. They're trying to identify areas where they can collaborate, particularly in the regulatory front as well. But the model is fairly simple. When one thinks of social networking technologies that enable people all to come under the one virtual roof, it just makes sense to identify areas where there's work in common, where it's not competitive, where you could put together a dream team of advisors and share the cost. And this is what I call the collaboration strategy. In 2008, people thought it was nuts, but actually, I've got 7 or 8 case studies from around the world where it's actually happening.
Thank you. Yes, please, Paul.
We have been doing this at EMC. We now have what we call a federation. So we have EMC Corporation, which is the publicly traded company. And then within that, we have EMC Information Infrastructure, which is, let's just call our hardware business. Then we also own 80% of a company called VMware. And we have a new company in big data called Pivotal, which we own the vast majority of. And then we have a joint venture with VMware and Cisco called VCE. Each of these entities has general counsels. Some of them have worked for me. What we do is, and VMware has their own legal group, but we coordinate as general counsels, and I lead those meetings once a quarter. The senior legal teams of EMC, each of these companies meet, and we coordinate and we also collaborate and we share the work. We are going to try to do more of having a shared service center in the business law area. Those are the commercial agreements. That's going to be a challenge because each of the companies has certain legal interests that they want to protect differently. But we're finding that it's an important thing to do, and we're working very hard to have a shared services operation. As the company, we have this in the in finance, for example, and we're looking to replicate it in a different way in legal. So it's a good thing to do.
Please.
Hi. I actually went to, I'm reminded of an experiment they did when I went to Penn Law. They took a bunch of us from the law school, a bunch of people from the business school, and they gave an experiment. They gave us some instructions, and we had to solve a problem. And and then they said, go. And the law students spent 15 minutes trying to figure out the rules and clarify the questions. And within 2 minutes, somebody from the business school would figure out how to get around it, and he'd solve the problem. Which is funny, but it's not so funny because I'm 15 years out of law school. I was a lawyer at a very large law firm for a very long time, and I'm now an entrepreneur. And I can tell you, as somebody who has worked with lawyers and business people as a client, now as a business person, entrepreneur myself, who sees lawyers, I think the issue is that law school, first of all, people who go to law school are sort of inherently risk adverse. They probably thought about business school and chose law school for that reason. And second, they're then trained specifically to do nothing new. So if you've drafted something and the question is, where's this from? If you say, I drafted it, that document is dead. Don't use that. I don't know what the risk is in that document. I don't want you to do anything. And yet you're a problem solver. That's your job, is to think creatively outside the box about a problem and solve it to the end. So to say, I run 28 clinics and what I need is X, find somebody at those clinics who wants to solve that problem. That's what they should be doing. They should have a problem and solve it. Hack it, fix it. That's what they're supposed to be doing. And what I see as an entrepreneur, if I get one more lawyer who says I'm a quick learner and he wants to learn on my dime, he doesn't even get my business. He doesn't even get what I'm doing. And I think that it's a shame. That's really the disservice. It's, you know, I'd rather take a developer who his every thought is, how can I do it better? How can I do it faster? How can I make my life easier? Instead of a lawyer who's like, let's talk about it a really, really long time and let's hire somebody to fix it. And it's just an inherently uncreative way of thinking, which is, I think, handicapping lawyers because their clients are becoming increasingly creative and interesting, and lawyers are not, I think.
If I could answer that, I hear you, but lawyers in representing clients and companies like EMC, they have to go with what we do. They have to innovate. They have to change. Everybody's out there facing huge fiscal pressures. Everybody knows change has to occur. Everybody will tell you change has to occur. And those that will survive will make those changes. I can also tell you in Massachusetts, in the court system, the courts realize that one size does not fit all. The Massachusetts Superior Court has now established a drug court, a mental health court, a business litigation session, and they just opened yesterday in the Boston Municipal Court a veterans court. They realize that there has to be an innovative way to deal with very serious societal issues. And the judges are working in collaboration with the mental health agencies, with the probation department, with the lawyers, both the prosecutors and the defense. And I think you're going to see more specialization coming because of this. And so that is innovative, and that shows that lawyers and government is willing to change.
I'm drawn back to Professor Christensen, to his comment that I don't think that the institutions that are, that the innovation is going to come from within the institution thinking about it. I think you're going to get some great developer who's going to develop a great app that's going to allow lawyers to quickly serve a particular problem in a particular jurisdiction, and then the ABA will just have to figure out how that fits into their structure.
Well, I can't speak to the ABA, but I will tell you that Professor Christensen's analysis is right on. And again, focusing in on the judiciary, the private litigation process was established and has been thriving because litigants and lawyers have perceived the judiciary as unresponsive to their needs. You are now seeing, however, for example, in Massachusetts and 20 other states, the establishment of business courts or complex litigation courts that are specifically established for litigants with complex issues. The tide is turning now because we believe in the Constitution, we believe in the three branches of government. We, contrary to popular belief, as a corporation, are seen as a person in the eyes of the law. We have rights under the Constitution, as does any other litigant. And we see the trend moving back into the courts versus the private litigation process. That occurred because of disruptive technology, let's call it, and the courts have responded to that just like companies do. Now, it is true, some companies have not adapted and they have gone out of business. Government will not go out of business, but you can see eventually they will change and they will meet the competition.
Martha.
I wish I could tape what you said before our students take the required problem-solving class, because what you said is exactly right, and thinking out of the box, thinking collaboratively, thinking about how you solve this problem, that's absolutely something law schools need to be doing, and we have talented people who can learn to do it. However, well, and I'll support that also by saying the innovation lab at Harvard created a problem for me. I get a phone call saying, you have an immigration law app, but it's inaccurate. Turns out it wasn't made by our immigration clinic, it was made by some business school students. That's great, but they ought to collaborate with the law students so that they actually get the law right. That would be helpful. That's part of my bigger point. We had a financial disaster in part because people got around the lawyers. So we cannot unscramble the real estate problem because people bypassed the, there's a reason we have a legal system. And what we need is collaboration so that the lawyers are actually part of the discussion rather than bypassing the lawyers. Because otherwise we're going to have a lot more messes.
Maureen Dowd said, thinking outside the box is great, except you have to remember the box is sometimes there for a reason. So, Heidi.
Well, so the word collaboration has come up so many times in this session I lost count. And frankly, for someone who's a scholar of teamwork and organizational behavior, that's absolutely music to my ears. But my question, Tom, is that you used the term collaborative intelligence. And I'm curious to know whether you find that law students, recent graduates are coming out prepared with collaborative intelligence, and I'd be curious to know what you think we could do differently in law school education, legal education broadly, to improve collaborative intelligence.
So, Tom, before you answer that, the dean has to make a getaway before she also has to answer Heidi's question, but Heidi's around so she can ask it later. But please help me thank the dean for everything she's done to make this possible. Thank you. All right, Tom, you're now in charge of legal education.
You're in trouble then. There's a book you ought to read. Let me offer it. Erin Reeves, she's a professor at Northwestern University, the 21st Century Leader, and it's all about collaborative intelligence. I made this pitch at another law school, and they said, well, how do we go about doing that? And I rocked a bit, and all I could come up with at the time was, well, you all get together for study groups. That's one form of collaboration. But I didn't have a very good answer, and I don't now for you today, but that is something that is a hallmark of how we're going to look at the future talent. Do they have the ability to draw from different perspectives, and are they willing to do so, and not rely on their own innate intelligence for every decision that needs to be made, and they have to do it with a great speed, and they have to do it across borders. So it's something that it'll distinguish the successful multinational corporations from the others. And when you've got somebody in South Korea and he's one lawyer, or somebody, one lawyer in the Ukraine, you have to have the ability to, she has the ability to collaborate and develop that skill set. Otherwise, we're not going to be very successful, I think.
If I could add, I view that as teamwork. Everybody has to work together as a team, and we're only as strong as our weakest link. For example, when we litigate and we do take cases to trial, we work together as a team. And we have lawyers now that we've stayed with for years. If we have somebody that does not want to work as a team player, we get rid of them. We've had some very unhappy experiences with some very prominent law firms because they will not work with us as a team. We know the facts better than they do. We go into court with them. We help them try the cases. We do all the legwork. And if they don't want to work with us, then we'll move on. Same thing on transactions. I know certain parts of the law and deal work better than my transaction lawyer. He or she may know certain areas of the law better than I do. But we work together as a team, and if that doesn't happen, we can't let it happen. We can't work with that.
And that's inherent in our network. We have 34 firms, erstwhile competitors outside their service to DuPont, but within that network itself, they're expected to collaborate with these fellow lawyers amongst this network of law firms to advance DuPont's interest, even, again, if it's not necessarily in their financial interest. So this is a thing we've been preaching for quite a while, and hopefully you've been somewhat successful. Very cool.
Please.
We've heard a lot about technology as a way to disrupt the legal profession. You heard from my colleague Andrew Finkelstein about one of the ethics rules that we're challenging about non-lawyer ownership. But I'd ask for comments from this panel on some of the other basic ethics rules that keep, I think, to the detriment of customers, of clients, everything from our inability to practice across state lines and not be able to admit it into multiple bars in order to protect turf, limits in our ability to tell potential clients about why our service might be better than another law firm's, or to compare and compete on prices, to fee-sharing rules that limit our ability to make sure that the case gets to the right lawyer, as opposed to just keeping it, you know, to incent folks to keep a case that they may not be the best lawyer to provide the service for.
Don't forget confidentiality in that mix as well.
Absolutely.
Yeah. So Delaware is where I'm licensed, and they've got a special group together of judges and practitioners that are trying to come to grips with all of these issues and set forth a expectation with respect to the lawyers now, because, as you know, the ethical requirements now, I think, mandate that lawyers be proficient in IT and how they use it and it's utilized. And so it's a big area of concern, because it depends on which lawyer you talk to as to what they think their obligations are with respect to the use of technology. And the question I struggle with, if your files have been breached, do you have an obligation to notify your client? And I've gotten 6 different answers from 6 different firms. So those are the sorts of things that need to be sorted out, I think, by proactive bar leaders and others, that because I think the average lawyer, the single practitioner, is really going to struggle with this, and certainly the lawyers in those larger firms will as well.
David?
Next question.
Yeah.
David?
So my,
oh, I'm sorry. Richard, did you want to say something?
I just wanted to throw in one of the concerns I've had, and has been expressed to me by a number of innovators in the US, is the possibility of online legal services, particularly for people who cannot afford lawyers, and systems that really would genuinely widen access to justice. These systems being challenged by state bar associations and others as unauthorized practice of law. I find that I can understand some of the thinking behind it, but as a matter of principle, it seems to me we should be open to the idea of developing systems that make legal guidance, legal documents, legal help more readily available, more easily accessible. And I think we need to, interestingly, a confusion that often US people have about liberalization in the UK is they think it means no regulation at all. Liberalization is not the same as deregulation. So I don't think anyone over here is saying we shouldn't regulate such services. But what we are saying is that to strike them down as unauthorized practice of law is unhelpful at best, and actually at worst really could limit access to justice.
Thank you. Last question.
Yeah, so my question and comment was, I think you used the term collaboration and teamwork, but I think what we should be using is cross-functional teams. And I'm kind of unique in that I've gone to electrical engineering school and business school before I went to law school. And so one of the things that I discovered when I was in the MBA school is that the law students that would come in, they seem to still lack that ability to work with different types of skill sets. So what I would profess for legal education to take forward lawyers into the next century is that every lawyer in their first year law school take the first engineering class that any engineer takes, whether they're an electrical engineer or mechanical engineer, which is a project EC 100 type class, which they work with different skill sets to create something. And I'd profess that it would be wise for a first-year law student to also take an entrepreneurship class where they work with different people to create a potential business plan. And that changing the order in which people learn legal education so that they learn the context in which they're learning would fundamentally alter how lawyers would come out at the end. Because in my view, when I went to law school, one of the first things I saw, having gone to engineering school and business school, was this tremendous change in how people were programmed in the first semester to study and be isolated rather than work in teams. And when they get out, that carries forward.
I'll just say that I often say that lawyers are the only people in the world that divide the world into two groups, lawyers and non-lawyers, as if they are two equal groups. Here's a hint. There's a lot more of them than there are of us, and that is a fundamental problem in a world in which boundaries are porous. It's a network society in which people have to work together. Others, did you want to say, Tom?
I think that's right on, and that was the crude analogy I was using in the introduction. You need to learn to speak the language of the business, and of course, you can't do that if you keep these lawyer blinders on. You've got to engage with those people that you'll be working with, whether they're engineers or otherwise, and I think there's a real art and skill to that.
I agree on collaboration. However, even for law schools, they have to identify the market that they're seeking to serve. For example, Harvard would look at one particular market. Suffolk University Law School down the street in downtown Boston may look at a different type of market. So that would be good to have those programs, but it depends on what the law school is focused on and where the practitioners are going to go.
Right. And the diversity of skill sets of what they're learning is what would be wise for lawyers to learn, because it's not just lawyers working collaboratively with other lawyers, but lawyers working with engineers, computer science people, with business people, together to solve a problem. And that will be required later on, too. And by the way, I used to write patents for EMC.
You know, a great example is in cybersecurity, and I think Paul and certainly DuPont are under siege, both from competitors and state-sponsored security, and you've got to have the ability to collaborate with your IT professionals, and if you don't, I think you're going to not serve your corporation well, and we're struggling with that right now, so that cross-discipline collaboration is so critically important in order to meet that challenge, which is pretty severe.
Well, the one thing I know for sure is that you have guided us, all of us, in thinking about how we ought to think about these problems and where the challenges are. Please help me thank the panel for an amazing panel. Thank you.
Oh, likewise.
Okay, you've made it. Now, you might have noticed on the schedule it said something like half an hour, and I was going to give you some brilliant wrapping up keynote address, but that strikes me as a bad idea right about now. So instead, let me just say very few observations and then an invitation. So, first observation. It probably didn't, lots of people have said that this is a market that's ripe for disruption. And just to pull on what you said, you know, law, I often say, is the only business in the world in which you can't say anything new unless you absolutely prove someone said it before. That's what we call precedent, and that's the way in which we teach people. Not likely to be very innovative. And so we have a whole day conference on disruptive innovation. But where do we have it? In the Ames Moot Courtroom, the oldest room at Harvard Law School, sitting in front of the bench where Supreme Court justices sit. And who's here? This is a conference at Harvard Law School. I think you could count on one hand how many Harvard law students are here, other than the ones we specifically invited. It's not for lack of information. There were posters about this all over the place. We've talked about it. We've talked it up. And yet the very people whose lives are most likely to be disruptive had other things to do. Now that suggests to me this is not going to be easy, that there are going to be lots of resistances, as I think, Sarah, you started us in the first panel thinking about. And some of those are about regulation, but my sense is, and this is partly because Hubbard has been absolutely fantastic sitting here all day, and he's taken a lot of slings and arrows of outrageous fortune. But don't forget what Chris Kenny said. They've deregulated to a very substantial degree, and they have not, at least as of yet, seen the kind of disruption that I think many people had predicted, for better and for worse. Moreover, a lot of what could be done inside legal departments. In fact, you heard Marty Mazzoni and other people talk about what's already going on, in which the regulatory barriers, quite frankly, are not the issue. Right? I mean, you've got multidisciplinary practice, you can hire whoever you want, you can put in whatever systems you want. So I think we have to look more deeply at where the challenges are. And yes, some of them are cultural and attitudinal, but some of them are the very fact of what are we trying to do by disrupting the legal profession? That is, what's the goal of disruption? When some people talk, the goal seems to be put the big law firms out of business and reduce the costs. That is one possible goal, but that's a pretty inwardly focused goal. For some, it is provide access to justice, but that immediately leads us to a set of questions about what is access to justice, and what are we trying to give people access to? Is it providing lawyers or lawyer substitutes? Is it providing ways to give people access to dispute resolution quicker and faster? Or is it something fundamentally different that we might think about that justice might mean in a society in which lawyers occupy a less prominent or important role? And of course, for some people, disruption is to disrupt the tyranny of the billable hour and the drudgery of being a young lawyer, or an old lawyer for that matter, and to make the lives of lawyers better. I think the problem is we have many, many goals, and we keep talking about something called the legal profession. But there is no legal profession. There is no single legal profession, and there never has been. John talked about big law and small law, or individuals, but that's just the beginning of the many distinctions in the kinds of not just work lawyers do, but the purposes of what we want lawyers to serve. And because those purposes are inextricably linked to the broader purposes of the legal system. So you heard the dean talked about the rule of law, or individual liberty, or freedom, or democracy. We could name a lot of goals which stand connected to the legal profession, but it's not clear at all that reforming or disrupting the legal profession would actually resolve those larger problems, or that you could think about reforming the legal profession without thinking about what that means about law and its connection to sovereignty, legitimacy, democracy, etc. So this is going to be a very big challenge. And just as the person from the IBM Watson project said, we're just at the beginning of the third age of computing, I think we're just at the beginning of developing a 21st century answer to what does it mean to be a lawyer? And what are the purposes of law and the legal system? Right now, we have a 19th century answer. And that 19th century answer has served us pretty well. That is, in many ways, we do not want to throw the baby out with the bathwater. That there are many things that are quite important about having an independent legal profession, about having a profession that is dedicated to goals larger than just a market. So yes, we've made a lot of progress by understanding that the legal profession is also a business. But of course, it can't just be a business, because we entrust it with so many important things that are crucial to our liberty and our democracy and our lives, that we know markets may or may not actually produce, right? We know markets are great at producing some things. They're not great at producing other things. And if we're thinking about what's going to happen to the legal profession, we have to think about both parts of that equation. So here's the request. This can't end here. For myself, and only speaking for myself, this has been an absolutely thrilling day. And like many of you, I cede to no one having gone to more conferences on the future of the legal profession. I'm older than Richard, so I've got him beat, and you know, it's my job, and I've been studying the legal profession since I became a legal academic in 1986. And I've been going to conferences, many of them, ever since. And very few of them have had the level of substantive engagement, the level of cross-pollination, the level of new ideas, the level of aha moments, for me, that this one has had. And if you agree with me, then we have to keep the conversation going. And that's our challenge. How do we do that? I mean, maybe, and I promise, maybe we can convene again as a group like this, maybe next year. But we have to find a way to keep the conversation going in the interim. Most of you who are here were very good at answering a very simple form that we put my amazing assistant Nathan Cleveland, who's kept all the trains running on time and always keeps me, if not running on time, at least tolerably not on time, put up to just, you know, put your contact information and say you wanted to come. We're trying to find some way simple like that to capture ideas about where we go from here. Because if you remember what Clay said, we've got big challenges. And it's not to say that we should be protecting the incumbents. And I agree with you that innovation is less likely to come from the incumbents. And that includes almost everyone in this room who is living and working in the United States. It's probably why I invited my Brazilian friends and we tried to get others to come. And many of you came from other countries. I spend a lot of my time looking at the emerging economies, and I think that's where we're going to see a lot of the innovation come from, of necessity. So, the request and the hope is that you will find ways to stay in touch with us. We're not hard to find, either physically or virtually. Let us know what you think would be a good way to continue this conversation. We will try to think of ways that we can reach out to you. We have all of your contact information, which we greatly appreciate. But for now, I'd like to thank you for an incredible day of incredible attention and hard work. Everybody here worked probably as hard as they do in their real jobs, and yet had to keep going with their real jobs while they were here. We have some modest but alcoholic refreshments downstairs, which we hope you will partake in. We hope you will keep thinking. We hope you will keep innovating. We hope you will keep disrupting, and we hope you will keep in touch. Thank you all very much.